Welcome back to We the Plaintiffs, a podcast built for law students destined for the Plaintiffs Bar and the Courtroom. My name is Corbin Winward. I'm a rising 3L at Baylor Law School, and I serve as the president of the Baylor Plaintiffs Law Association. Today, I'm joined by two outstanding plaintiffs' attorneys from the Lanier law firm, Rachel Lanier and Sarah Lanier. Rachel Lanier is the managing attorney of the firm's Los Angeles office, and she served as co-lead trial counsel in the landmark social media addiction case against Meta and YouTube. She practices in the areas of personal injury, toxic torts, pharmaceutical litigation, mass torts, and product liability. Rachel has held leadership roles in major coordinated proceedings, including the social media JCCP litigation. Rachel has helped lead high-stakes cases involving corporate misconduct, product liability, and consumer harm, and she has been outspoken about the broader implications of holding social media companies accountable for the way their platforms affect children. I'm also joined by Sarah Lanier, an attorney on the firm's trial team whose practice also includes personal injury, toxic torts, mass torts, product liability, and pharmaceutical liability. And Sarah's work is centered on the courtroom, like presenting argument, examining witnesses, and helping translate complicated facts into a story jurors can understand. She has also become a leader in the firm's use of technology and artificial intelligence in trial preparation, from case themes and witness prep to creative ways of sharpening courtroom strategy, while staying thoughtful about the ethical guardrails that come with those tools. I'm excited to have both Sarah and Rachel on the show today to talk about the social media addiction trial, the different roles they played in it, and how their backgrounds give them distinct perspectives on where this litigation and plaintiff side trial work more broadly is headed. Thanks so much for joining us.
Thanks for having us, Corbin. We're excited.
Yeah, we're pumped to be here.
Yeah. So first, we're going to talk about your backgrounds a little more. Can you both briefly introduce yourselves a little more if I probably missed some areas in those short intros?
Yeah, absolutely. I'm Rachel, and I practice out in California, although I started off in New York. So our firm kind of does things all over the country, but I love being out in California. I love the good weather. I love the courtrooms out here. I really love being in a courtroom. I'm much more of a talker than a writer. So I knew from a younger age that I would need to do something for a living where I'm talking. So I love being in a trial, and and I love the LA food scene. It's a great place, the West Coast. So it's fun being out here, and it's fun practicing out here.
Awesome.
Well, I'm Sarah, also at the Lanier law firm, but I'm based in our Houston office. I graduated law school about 2.5 years ago, so summer 2024. So as a younger attorney, kind of still finding my footing in the law firm. But that being said, it has given me a lot of opportunities to do really cool things. I'm technically a member of the trial team, so I get to work very closely with Rachel, which is the most fun thing ever. But in addition to that, I have a smaller personal injury docket of my own, so I can get into the courtroom more and do a lot of argument. I had my first solo trial a couple weeks ago in Houston, which was really cool to get to do. Yeah. So I've loved it so far.
Cool.
And Sarah's being modest. She is like 2 years out, but and I've been practicing 11 years now, and she's going to surpass all of us very soon. She's dynamite.
Rachel's a little biased because she's my sister, but I appreciate it anyways.
Well, yeah, you obviously both come from a serious trial law family, Mark Lanier being your dad, but you've each developed your own path and your own strengths, I see. And so how did each of you find your own voice as plaintiffs' lawyers?
A really good question. And I think when you get raised in a family where both of our parents are lawyers, although our dad obviously did more of the day-to-day work once our parents had kids and everything. Our mom focused on wrangling, mediating disputes between kids instead of people suing each other. But it's interesting how we both kind of found our own path. I really love psychology. That's like a unique kind of our dad, we call him Mark in the workspace because calling him our dad sounds kind of whiny when you're working together. And so he loves communication skills and things like that. I studied psychology in undergrad, and I like understanding how people work, why people think what they think, what people's different perspectives and backgrounds and viewpoints might be, and how do we apply that in a courtroom? How do you relate to jurors who come from all different walks of life? How do you make your witnesses be able to communicate to all different types of people? I also am the kind of person who I like creative kind of stuff. I like art and I get bored extremely easily. So I think that if we're going to be in a courtroom, we need to keep it interesting. I think if we're boring people to tears, we are not doing our job well. And I remember being in law school and being kind of worried because I am not type A. That's just not my personality type. I am I'm just much more kind of, I don't know. I think that there are so many strengths to being type A and being good with like a spreadsheet, and itemizing things and stuff. But I think that ultimately, if you want to connect with a jury, the most important thing to do is to be interesting enough to listen to. So
Yeah.
I think
Yeah.
that weaving in visuals is really important. I think that learning how to communicate and learning how people think, that's really my niche.
Yeah. That's great.
I'd say for me, the way I've kind of found my footing has been through working with a lot of different people. So it's the coolest thing ever to have the chance to work with family. And I think because of that, I've been blessed to get a ton of exposure to a lot of different law firms that we work with. I was fortunate enough to get to be part of the social media case that we did out in LA a couple months ago. And getting to work with other firms on assignments and on case workup, getting the chance to work with a bunch of different attorneys kind of shows you that there's no one size fits all approach to being a lawyer. Everybody does it differently. And I think having that kind of exposure early on in my career has helped me in my own cases. I know that there's not one way to lead a meet and confer. There's not one way to negotiate what exhibits you want to agree to. Everybody kind of has their own style. So I think having that exposure early on and also getting to work with a bunch of different people at our firm too has kind of opened up my eyes to that and has been really helpful for me within my first few years.
Awesome. So, what drew each of you to trial work specifically in plaintiff's work as opposed to other areas of law?
Ooh, well, like I said, I'm a talker, so
There you
I
go.
knew I could
Yeah,
not go into legal writing. I
that's
have
right.
mad respect for people who are great writers. Legal writing was never my strong suit. Talking, asking questions, drilling down, cornering people, that's kind of more my area, my strength. And I think also the storytelling component is so fun and interesting, and trying to right a wrong and letting the average American jury decide what's acceptable in our communities, I think is such a cool thing about the US. I think it's a great thing about our jury system, our court system, the legal system. We're often the last line of defense for bad conduct. And so there's something so cool about that to me that I've always really loved.
Yeah.
I was kind of drawn to trial work for honestly as long as I can remember. When I was growing up, our dad would always come home and talk about his day at work or his trial and paint it as if he was a superhero taking down the bad guys in the courtroom. I remember one summer when I was in elementary school, I spent the entire spring break watching him in trial. And like Rachel was saying, he does a good job. Something that he definitely tries to do as well in his cases of making it interesting. And so even in elementary school, I thought it was so cool what he was doing. So I always knew I wanted to go to law school and I knew I wanted to emulate that in some way, shape, or form. But as I did, high school, I did speech and debate. And in law school, I got really involved in mock trial, moot court, took all the advocacy classes. And I think it just solidified for me that I really enjoy oral argument. I enjoy getting to give a presentation. I enjoy public speaking and kind of getting to do it with people that I really like working with is just the cherry on top.
Yeah, that's great. So, this question's for you, Rachel. As managing attorney of the LA office and co-lead trial counsel in this Meta YouTube case, how would you describe your role in shaping the trial strategy?
Great question. There's kind of two components. One is mechanical and one is more substantive. So, from a mechanical standpoint, everyone's kind of heard the phrase, it takes a village to raise a child. Well, it takes a village to raise a trial. Like, in order to get to trial, you need to have all these people and all these pieces in place. It's almost like I analogize it to building a machine, and I was in charge of building the machine. And
Yeah.
I'm a part of the machine. And so part of it is figuring out, like, this person fits in this area, and that's where they really shine. That person fits right here, and kind of putting all of that together for the greater good and for the trial. And then being a part of that machine too, so that then once you press the on button, you go and it works.
Yeah.
And so that's kind of the mechanical component to it. A lot of teamwork, a lot of figuring out what people are interested in, but what they're really, really good at too.
And if I can just say, to brag on Rachel, her nickname is TC, which stands for team captain, because she's able to
Nice.
rally the troops, and she does it in a way that everyone's excited about, but gets things done so efficiently. So from a mechanical standpoint, there is no one better to rally the troops.
Well,
That's awesome.
that's very kind. I believe, if we're saying the machine is a car, for example, like, the car can't go if it runs out of gas. So it's really important to have a good team component, to have good work-life balance, and that's difficult to do in this field. So I am happy that Sarah said that, because she's a member of the team too. So that's a good thing. And I've learned from others a lot in this area. From a substantive standpoint, there's so much that has to be done. And again, it is a team mentality, but trying to, some lawyers, and when I was in law school, I kind of thought a trial was like the plaintiff lawyer stands up and says all the good things about the plaintiff and then sits down. And then the defense lawyer stands up and says, like, all the good stuff about the defense and then sits down. But when you're really trying to communicate a story, you have to be willing to tell the good, the bad, and the ugly about your side. You have to be willing to embrace the good facts and the bad facts in your case and turn them to good. So let's say your plaintiff is already hurt and has a lot of issues already before they even ever meet the defendant in a case. Well, then you have to deal with that. You can't pretend like your plaintiff, all things were perfect and the defense ruined everything. Instead, you have to kind of accept and embrace that you have a vulnerable plaintiff. You have an eggshell plaintiff. You have a vulnerable person, and that's the last person that needs to be getting injured. That's even worse in a way, that they were already hurt and it just made it so much worse. And so that's sort of, there's a lot of things like that, but our team focuses on a lot of that. And I'm happy to get to lead that and be part of that with tremendous, brilliant, smart people.
Yeah. A lot of great attorneys at the firm, for sure. And then Sarah, we talked about you being part of the firm's trial team. What parts of trial work do you think you're most drawn to?
The trial work that I do kind of differs based on the case. So for my own PI docket, the smaller cases that I have, I get to do all of the trial work, which I would definitely say is my favorite. I like being up there doing jury selection, giving opening statements, doing the directs and the crosses and closing. I think it's so fun to be in the courtroom and to have all the energy in there and really get to just do it all. But aside from just general courtroom work, I really enjoy brainstorming themes, theories, ideas, demonstratives. The trial team that we have is very inclusive of thought and ideas. Everybody's ideas are taken into account. There is not a role at the firm where you shouldn't be speaking up if you have an idea on a theme or a theory. One of the best theme ideas that we got for a trial we had a couple months ago was from somebody in IT that was helping with a computer issue, who heard us talking and piped up with an incredible idea. So I really enjoy that part, just the collaborative talking through the best ways to frame a case and themes and theories, in addition to all the actual trial work itself.
Cool. So for both of you, when you're working on the same trial team as a family, how do you balance that family dynamic with the seriousness and pressure of a major case?
I'll hop in. I think one thing Sarah and I are very mindful of is the Nepo baby culture, where it's sort of like, you know, you get your foot in the door in different places that other people may not have, just because of who you are or who you're related to. Sarah and I try really hard to work harder than anybody else around us, and everybody around us is working really hard. We try to be the last people to go to bed, the first people to wake up. And at a trial, it's really important to kind of lead by example and show that you are willing to get down in the dirt and do the unlikable tasks and the things that lead to paper cuts and the things that can be kind of the less glamorous part of trial. And when you're willing to do all aspects of it, I think it helps the team's culture and mentality. I think that's really important when you're working with a family. I think it's really important to highlight and bold and underline other people's roles and efforts over yourself. I think that when there's, a quiet person on the team who's contributed such a massive amount, it's important to vocalize that, because we're lucky enough that we get to work with our dad, which means we get to give major kudos to people and know that, we can give our dad feedback and know that we're probably you know we can annoy him. We can annoy him and know he'll still love us, that
Yeah.
kind of thing. At 4 a.m., we can be like, no, that's a horrible idea. We don't like that. Don't do that. No, that's going to sound stupid. Like, we can be very blunt with him. So it's unique. And I think the key is to highlight those around us, because other people don't always get that role and that ability to be like, hey, boss, here's what I did. People
Yeah.
don't tend to do that for themselves.
I'd say at the same time, it's just so fun getting to work with family. I think before I started law school, Rachel is older than me. She went to law school before. And so I had the privilege of watching her navigate the field as her own person, in addition to, like she said, getting your foot in the door for some really great opportunities, but then working her tail off to make sure that not only does she deserve all the opportunities that she gets, but then that she gets opportunities herself. So getting to watch that for me was really helpful before starting. But I will say, when you are in trial for 2 to 3 months and you are getting maybe 4 hours of sleep a night, there is nothing more fun than getting to work with a sister, because you just understand each other's humor on a completely different level. You know exactly when the mood is too tense and you need to crack a joke, but also, like Rachel was saying, picking up the jobs that nobody wants to do. Being a team player, I remember it was 1:30 a.m. one night in trial, and we had a fantastic judge in the social media trial. And we wanted to create with defense counsel kind of this joint list to keep track of some documents to try to make it easier on the court staff because of all the stuff that they were doing. It was 1:30 a.m. I had probably 5 hours left of work to do. And Rachel's like, all right, count me in. Like, let's do it. So it's very fun getting to do stuff like that with family.
Yeah.
It is very fun working with family, because and also because I remember what it was like without Sarah. So it's really fun having Sarah because also we can kind of like tease or make fun of our dad to each other and give him our time and be like, Sarah said you were doing
Yeah.
this. And
It's funny.
it's funny. It's really fun.
Yeah, it sounds like a really unique experience, but also, I appreciate that you're also mindful, because it'd be super easy to just be like, you know what, like I can do anything and still have a great position here. And I've seen that with some firms, and it's disappointing for everyone else, but everyone I've talked to loves you guys. So it's awesome.
That's awesome. Well, we love
Got a great
the
team.
folks we work with. We have a great
Mhm.
team. And the idea of like just getting a job because of who I am and then doing nothing, that's like my worst nightmare. I just think that's awful.
Yeah.
And so I know Sarah feels the same. So we do try very hard. And so I'm glad. I hope it is felt by others.
I think so. Yeah, for sure. So we're going to shift to the Meta YouTube case, and then we're going to open it up to both of you again. So for listeners, in case you may not know about this case. What was the core theory of that trial?
So the core theory is that the defendants that were left at trial, these social media giants, Meta in charge of Instagram and Facebook, Google in charge of YouTube, created platforms that exploit and addict children. And once you're in, you're hooked and you can't get off of it, especially for a child. Their brains are different, they're more vulnerable. And we represented a young girl who was 20 years old at the time of trial, but she was very young when she was exposed to these apps. And she went down the rabbit hole and couldn't get out of it because of these addictive algorithms. And it caused tremendous anxiety, depression, body dysmorphia, and disordered eating issues, suicidal ideation. And unfortunately, she is one of thousands. These companies have impacted a whole generation of children, and they need to be held accountable.
Yeah, thank you for that. So this trial has been described as a landmark social media case. And why do you all think that it is appropriate landmark?
Sarah, what do you think?
It was the first of its kind to be tried on social media addiction in any capacity, but it brought up novel issues that hadn't really been addressed before. There's a big hurdle that we knew was going to be brought up in trial. It's called Section 230. And it's the idea that you can't hold a company responsible for the content that's on their platform. So if our client was bullied by a comment left on her Instagram post, that's a hurdle for us to face at trial. We need to show that her harm didn't come from a comment of being bullied, but came from the features and things created by the company. So this was one of the pivotal moments for this whole litigation because we got to see how a jury could disregard content, disregard everything addressed by Section 230, and just look at the apps for how they were created and see how harmful they really are. It was also pretty unique because we got to have in the courtroom to cross-examine company representatives like Mark Zuckerberg, Adam Mosseri, Christos Goodrow, some very high up and influential people. It was also really important because there are a ton of people that have been harmed in so many different ways by social media. And this was sort of the first moment that these companies were going to be held accountable, and in the courtroom especially. So heartbreaking, but there are hundreds and hundreds and hundreds of people who have lost their lives due to social media addiction, due to just horrible, horrible things from these platforms. And so every day outside of trial, there were parent survivors of children who have lost their lives due to social media. Their parents flew out to California and would come watch trial every single day. They lined up outside the courthouse some mornings at, what was it, Rachel, 1 a.m. to make sure they could get a seat. They slept overnight in the rain outside just to see that accountability because it hadn't been brought to them before. And it was a case that wasn't about their child. It was about a girl they had never met before, and they showed up every single day. So there were a lot of eyes on the case from so many different perspectives. There was a lot of media surrounding the case, but truly was a landmark in that it was the first time these issues were really being tried in this way.
And that's great. Yeah. And they probably had to get there that early because Meta was trying to pack their own people in there, right?
Yeah, they were. That was crazy. And YouTube, they were paying people because there were limited spots in the courtroom, and there were way too many people who wanted to be in there, and also media and reporters. And so they had a ticketing system where if you lined up, you could get a ticket. And if you were out of luck, you were out of luck. And YouTube and Meta were paying people to wait in line just so they could fill it with their own people and come in right before court starts. So their own people wouldn't wake up at, 2 a.m. and wait in line, but they would pay too.
Wow. That's crazy. Yeah.
Yeah. So that the parents of people who committed suicide and kids that committed suicide couldn't get in. It was
the
crazy.
people that want to be there for their own, not for financial, like protect me, have more of it. Yeah, that's nuts.
Yeah. The shenanigans in this case were crazy.
Crazy.
Just crazy. I mean, when Mark Zuckerberg testified, the jury was supposed to be anonymous and no one was supposed to know who they are because obviously these companies, they make money off of information. So information is their business model and data and the data collection. And they would have known so much about the jurors that nobody else could have known. They could have influenced them. They could have impacted them. They could have influenced their employers,
Right.
people in their family circles,
Right.
push advertisements at them to kind of push the narrative on the defense. So that was very unique. The big tech companies that we were going up against. And when Mark Zuckerberg was testifying, his bodyguards were wearing meta glasses you're able to take pictures, you're able to make recordings, and the judge was so angry about it. I mean, she was floored that they did that.
Yeah, didn't Mark object? And then the judge was like, you need to delete everything, take those off.
Yeah.
Because there's not supposed to be cameras in here that are taping. Yeah. That's crazy.
It was crazy.
So the defendants argued in different ways that the platforms were not legally responsible, whether it was because of family circumstances, causation, addiction definitions, or YouTube's argument that it wasn't really a social media company. So what defense theme did you think most needed to be answered clearly for the jury?
There was a parental responsibility component that we needed to tackle. And we needed to own the fact that parents do have a role. But when you put a parent up against a multi-billion-dollar tech company, they don't really stand a chance. And when there are these so-called parental controls that don't work very well and were put in place way too late, and that the companies know kids work around, that's not enough. That's not doing enough. And I think also the fact that our plaintiff was vulnerable. She did have difficult things go on in her life. She did have a hard childhood, and there were other things that contributed to her mental health injuries in addition to the companies. But the companies, they know that vulnerable people are more likely to become addicted to their platforms, and they don't do anything to stop it. They don't take advantage. They take advantage of vulnerable people, especially vulnerable children. So one of the analogies we came up with that we brought up and that really resonated with the jury was when a lion is hunting a pack of gazelles. The lion never goes after the strongest gazelle. The lion goes after the weak. The lion goes after the small, vulnerable, young one. And internal company documents even said the young ones are the best ones. That was one of the documents. So the companies knew they were doing this, and they did it on purpose.
I think a lot of the problems that we anticipated were going to arise for certain jurors in their mind, it's interesting because it all kind of depended on the age of the jurors. So there's sort of a general consensus, you could argue, with certain age categories about how they view social media. So for a lot of younger jurors, they understand immediately that an app like this could be addictive. But for a lot of people who didn't grow up on these platforms or maybe aren't on them at all, don't understand immediately how you can get addicted to something that's on your phone, how you can't just put it down. They didn't understand the way the algorithm works, how it's like a digital slot machine when you scroll down to refresh for new content. So kind of figuring out also how to reconcile between jurors who maybe grew up on these apps versus jurors who maybe have never touched a computer in their lives, figuring out how to explain these apps to everybody and show them the addictive features, show them how the companies knew they were addictive, and get them to understand all of that was also, I think, an interesting hurdle that we went through in trial, and just kind of making sure everybody understood, what is an Instagram story? It's different than telling your story a friend over lunch. It's not a story that you tell, it's a picture that you post. So little things like that we noticed people were taking in different ways. So it was really important to kind of break things down to the very basics and walk people through them.
Sarah had to educate our dad on a lot.
I did.
She's being very nice. But our dad started out thinking it's stories are just things you tell your friends. Sarah had to sit him down and say, this is a story.
Nice.
And this is what infinite scroll is.
Yeah.
He
Yeah.
doesn't really use social media all that much, and he has his own, accounts, but he has people that help run them and post things
Yeah.
for them. So it was
Yeah.
pretty funny.
Well, it's just developed so fast, and we grew up with it, but it's probably hard for everyone to grasp that didn't.
Even to try and explain, like, this is what a beauty filter is versus just like a filter that's like artsy and it has, superheroes on it.
Cosmetic surgery filters are different than just ones that smooth your skin or put natural blush on or things like that. All of those little nuances to explain to the jury. That was an interesting thing to do too.
Yeah, I bet. So we're going to kind of shift to jury psychology and storytelling a little bit. So Rachel, as we discussed, your background includes a strong interest in psychology and, how jurors process information. How did that shape your approach to this case?
It was so fun and so interesting and fascinating because everybody has different perspectives on social media. We had jurors ranging everything. We had one juror who did not use computers at all, had no idea what any of this was.
Wow.
And we had jurors who worked on, different components of marketing and pitching to social media companies, had a lot of experience in that area. And so we had to figure out a way to make all of this make sense. So like one of the things that we did to visually explain how much our client had used filters on this app, Instagram specifically, we made this giant banner of these tiny pictures of all these pictures that she had posted with filters on them. And she even had medical records where it said, she cried at school today because someone took a picture of her without a filter on it. Like this was a big part of her body dysmorphia and disordered eating issues. And so we made this giant banner that was like, it had all these pictures and it was about 35 feet long. And we rolled it out when Mark Zuckerberg was getting cross-examined to show, like, do you understand how much kids are posting? This is just how much she's posting in the filter. So that was one example. We tried to keep it interesting, but I mean, that guy who didn't even use computers, he was like, his jaw dropped when he saw, but also that appeals to, and it also makes sense to people who do know what filters are and know how, how they work. So it worked for a range of jurors. So definitely visual communication was a big component of that.
Yeah. Another question for you, Rachel, and then we have a couple for Sarah. So one thing that came up in your trial academy discussion, the panel discussion, was authenticity, especially the idea that Mark is very much himself in the courtroom. How important do you think authenticity is for trial attorneys?
It's critical. It's critical. You are in front of a jury day in and day out, and people can tell when you're being phony. They just can. There is like a sense of unease about somebody who's not being themselves. And you can't fit a square peg into a round hole. You just can't. So you have to be yourself in the courtroom. You can be the most professional, intelligent version of yourself. I have a very bubbly personality. I can be very silly. And so in a courtroom, I'm not gonna, goof off too much, but I'm still going to be myself and I'm still going to be authentic. And so it is just really critical. And you can tell, we have seen time and time again where we start out the more creative ones, the ones that have interesting visuals, the ones that are using the Elmo or the little, document camera and with different markers and things. And we see the defense like start to panic a little bit and then they start trying to copy that, even though that's not maybe what they normally do. And you can tell it's obvious and they'll be like, oh, I'm not as good at doing this as the Lanier team is. And, they'll try to be kind of all shucks about it. But you can tell when they're not being authentic and being themselves. So authenticity is key because the jury can see that. And our job is to not distract them from the truth that we're trying to show them.
Yeah. I found that image here I want to show. And my camera isn't great. You see that there?
Yeah. There it is.
Huge. How long was it again? How many feet?
35 feet.
35.
Wow.
And each little picture was about an inch by an inch.
And this is all the times she posted online, right?
Filtered photos.
Not,
Mhm.
and it's not even all of them.
Oh, it's
Yeah,
just
it's
the
not even all
filtered.
of them. I mean, we had to have a whole data repository to hold all of her data because it was too much to hold on a physical computer. That's how
Wow.
much she was using these apps. She basically broke and blasted through the Google system. They only save like the first 80,000 videos you watch, and then they have to delete after that. And she watched so many that she blasted through their system. It was crazy.
Wow. Yeah, I think that's huge for a juror to see the visual, how many she's doing. And I know even some of them you had to put sticky notes over them because they were inappropriate, especially for her young age to be posting.
Yeah. Yeah. It was jarring for sure.
Yeah. Okay, Sarah, so a couple questions for you. So I believe at the Lanier Trial Academy panel, you mentioned that the plaintiff's mother was very nervous and that the part of the work was helping the jury like and understand her. So I'm wondering, what do trial lawyers sometimes misunderstand about preparing family witnesses?
I wouldn't say it was about getting the jury to like her as much as it was getting the jury to hear both sides of the story and really understand where she was coming from.
Okay.
A lot of the opening statements that we heard from Meta and from YouTube, like Rachel was saying, were kind of focused on the blame the parent role. And they, of thousands upon thousands of medical records, handpicked 3 maybe that portrayed the mom in what they would call a negative light. So there was one where our client, Kaylee, was in high school and she complained in the record that her mom didn't pick her up from school. She left her after school.
Right.
And they, defense counsel stood up and said, "Isn't it just so tragic and devastating that she was abandoned outside school and she was left outside school and her mother was too busy at the gym and didn't pick her up?" And we stand up and we say, "Okay, let's actually get some context here so they can understand the entire story." The mom did show up to school. Kaylee said she'd be done at 3. Mom left work early to go pick Kaylee up from school at 3. By 4:15 p.m., Kaylee still hasn't come outside yet. So the mom says, "If you can't come out when you say you will, you're going to have to take the bus home because I can't keep leaving work to come get you." Kaylee never even ended up having to take a bus. She ended up working the timing out, got some more responsibility out of it, and that was the end of the issue. But they made it sound like a preschooler was left outside school after everything shut down on the front steps. So it was trying to get the jury to just understand and see the full story without jumping to immediate conclusions about someone that they haven't met, or seeing Kaylee's screen time and automatically thinking, what was the mom doing? When in reality, the mom had safety devices installed on the phones. She had rules set up about screen time. So I think a lot of people try to, when prepping family, I think they don't focus on just the bigger picture. And I think they don't focus on, letting the jury find connections to whoever's testifying, getting to know the witness that you have on the stand, hearing about their hobbies, their interests, anything that a juror could connect with and think, oh, I do that too. Just helps kind of build a connection. It makes the client more comfortable. It makes everybody more comfortable in the courtroom because it's an intimidating atmosphere. But that was
Right.
definitely really big for us, was just sharing the whole story.
And to Sarah's point, kind of pointing out the defense cherry picking and the defense shenanigans. And we literally said, all right, let's deal with the mom shaming questions, because that's what it was. It was mom shaming. And it's sort of like
Right.
calling them out, like, come on, so it's a really critical point that Sarah's bringing up.
And it sounds like it helps to focus more on the personal rather than just our lawyer brains are like, okay, what are the elements? Let's hit all these things. Like, no, you need to go back to our human selves pre-law school and think what helps them connect.
Exactly. That's
Absolutely. Yeah,
huge.
because that helps the jury remember too. It gives them there's something called episodic memory, but when you're seeing an episode or a story of something and you feel an experience and it's sensory and you hear about sounds and smells and feelings and visuals, all of that helps people remember more too. So in a 2 month
Yeah.
trial, you really want to capture that and convey that to the jury.
Yeah. So follow up, Sarah, and feel free to chime in too, Rachel. So what makes a client story compelling? And I guess it has to do with the imagery as well, but what makes it compelling without making it feel overproduced to the jury?
It's got to be authentic. It has to be authentic. I tell clients all the time when I'm prepping them for my trial that I had a couple weeks ago, you just need to be honest. Jurors can see through a lie or dishonesty from a mile away. Everybody gets really nervous in a courtroom environment. If you're a witness and you've, never done this before, it can be really intimidating. There's somebody taking down every word. There's a judge in a robe. There's a whole panel of jurors looking at you. There are lawyers. There are people in the audience. It's such a scary experience for a lot of people that they're already, freaked out and not acting like themselves. But if on top of that, they're stretching the truth, it it doesn't serve any purpose. So I always try to tell clients the number one thing you need to do is be honest. Because if your case is going to trial, if I'm trying your case, it is because, we believe in you as a client. We have a good faith basis to bring your case to this courtroom. And I always try to tell them, I will take care of you if you get freaked out on cross-examination. It's okay. I get to come back on redirect examination and ask you questions. So I think just cautioning them to be completely honest and not try to over-exaggerate any symptoms or under-exaggerate anything that is important to them, but to be honest and upfront. And then in addition to that, kind of always starting off with just letting the jury get to know them always lets them be a little bit more comfortable. So asking questions about their families, about their hobbies, about their kids, always opens people up a little bit. And that's something that I noticed Mark did really well with Kaylee on the stand. Kaylee has social anxiety. So in addition to all the stressors I just mentioned for somebody testifying in a courtroom, it was like that times 50 for her. She's
Yeah.
also a young girl going against Google and Meta. So she is just incredibly brave to be doing this. And Mark did a really good job of obviously not making light of anything, but where she seemed to be having a hard time articulating her thoughts or getting worked up, trying to put in a little, a dad joke here or there, something lighthearted just to make her smile on the stand and make her feel a little bit more comfortable.
Like her
So
boyfriend's
telling,
name is
yeah.
Utah. So he was
Oh.
like he tried to make her feel comfortable right away. He's like, "Yeah, and you're here with your boyfriend. What's his name? Idaho." And she's like, "Utah." And the jury saw that and it instantly like helped her be a little more vulnerable and open up a little bit.
That's cool. So we're going to transition a little to kind of the evidence that mattered in this case. So using AI, ironically, was a huge part of this case and winning this case, against some of the biggest AI companies in the world. So I wanted to ask, how can trial lawyers use AI creatively for trial preparation without crossing ethical lines or outsourcing judgment?
Well, I know Sarah has a lot to say about this, and I
Yeah.
think you should
Yeah.
tell the AI engine
Yeah.
search story because that's really interesting. And I have
Yeah.
some tidbits I'll throw in.
I'll say up front, you always have to be cautious of whatever rules are in place. So I know there are some federal courts in Texas that require you to certify if you have ever used AI for anything related to the case. Even if you put in your proposed interrogatories and just ask Claude, did I miss anything? You have to notify them that you used AI. So knowing the court rules, and then also for our cases, a lot of the times we sign protective orders because we're dealing with confidential documents. So knowing the bounds of what you can and can't do is step number one, because if you're going to use AI, you have to use it ethically or else you run into some serious issues. But aside from that, there are so many creative ways that you can use it. I mean, the options are endless. For the social media trial, a couple weeks before trial, I started to think about how both Google and Meta have their own AI platforms. So I got onto both. I got onto Meta AI. I logged out of my account so they didn't know it was me. I'm sure they knew it was me, but so it didn't have all my data saved. And I said, is Instagram addictive? I'm expecting to get, all their arguments that they were going to give us at trial. No, it's not addictive. We have all these safety features, blah, blah, blah. But instead, the answer I got was verbatim. It said, OMG, you know it. And then it went through and it said the algorithm, the endless scroll, and it articulated all of the features that were addictive. Didn't even talk about the content. It talked about all the features and how they addict people. Like Rachel said, we had a plaintiff who had a tough background. So I said, is it easier or more difficult for people with tough home lives or for young girls? And it said much more difficult. And it went through all the reasons why.
Wow.
Google had the same thing. It articulated all the features that were addictive. So I think using it creatively is great. I know a lot of law students listen to your podcast. When I was a 3L in 2024, UT, I did University of Texas for law school, has a ton of advocacy classes. And we had a class where an entire unit was on jury selection, and they brought in 50 people that we could do a mock jury selection on. But I wanted to practice, so I used AI to emulate a model panel of jurors with the audio and voice recognition. Was able to ask it questions, get answers. So the ways that you can use it are truly endless, as long as you use it ethically.
Yeah,
Yes, of course.
it's awesome. Sarah's like our AI guru at the firm. So anytime anyone has a question about AI, they go to Sarah.
That's
And
awesome.
I loved also how we used it to find snippets in the hot documents. Because when you're going up against a big defendant, they document dump like millions and millions and millions and millions of pages worth of documents. And you have to comb through everything. It's like you picture like in the movies back in the day where people would have to go to these, they'd have all these boxes and you have to go through all the papers. That's like what happens now, but electronically. And so AI really helped us find a way to use the company's own words against them. So like Mark Zuckerberg, when he's testifying, and this is like a good cross-examination technique where you know what the document is that you're about to impeach on, but you don't use it yet. You give the person on the stand a chance to be dishonest. So we were asking Zuckerberg, you made company goals that would measure the amount of time spent by children on the app. And you wanted those goals to be increased year after year after year because it would make more money, right? And he's like, oh no. And he like gives the hedge kind of PR answer, like, no, I never used the goal of time spent. I never did that. And they're like, actually, you did. Here's exhibit, blah, blah, 105 that
Wow.
where you literally are saying, hey guys, our goal this year is to increase time spent. Or there is another document against the VP of engineering, Christos Goodrow, where he wanted to say, YouTube's so innocent. YouTube, you just watch things. It's just about viewership. People just like viewing things. We would never want to be, makes things addictive. It's not to do that. That's not what we've set out to do. And so we were able to cross-examine him and say, YouTube's goal is not viewership. It's not just people watching. YouTube's goal is addiction, isn't it? And he would be like, no, we would never do that. Well, here's the PowerPoint where your YouTube executives, including your CEO, are saying, the goal is not viewership. The goal is addiction. You're literally saying that.
Wow.
So I think AI can be so useful in cross-examination for that reason, for finding that verbatim phrase, and then you cross them, you trap them, and you impeach them.
Sounds like a lot of damning evidence was found.
Yeah. My husband's a lawyer, and he came for closing statements, and he had heard about this case from me, but he walked out and he was like, those are like the craziest documents I've ever seen.
Yeah.
He said it was crazy.
It just shows what happens when something's unregulated for so long. I guess they're just okay to email whatever to each other.
Yep, it was addiction by design. They made it. They built it that way intentionally.
Was there a moment where you felt like the jury understood the stakes differently, like there was an emotional temperature change?
I can think of one right off the top of my head. It's when we had Kaylee on the stand and she was talking about body dysmorphia. And she kind of nonchalantly dropped in there, how long it took her to get ready or something. And Mark was like, wait a minute. What time did you wake up, or what time did you have to leave your house today? And she said, 8:30 a.m. And he said, and what time did you get up to start getting ready? And she said, I think 3:45.
Wow.
And I think just for a lot of the women in the room especially, it was one of those moments that just, it was really hard to hear, because you see a girl who's so beautiful. We've seen videos of her where when she was a kid, she was singing at an open mic night in front of 100 people without a care in the world, who now has to take over 4.5 hours, much more than that, just to do her hair and makeup to get ready to go testify in court for a day. And just kind of how that anxiety plays out for her in that context. I felt a very big shift in how people viewed her after that statement was made.
That was huge. The jurors, we got to interview them afterwards too. And that was really interesting. So
Yeah.
what Sarah said really impacted them. When Zuckerberg on the stand tried to say with a straight face that kids under 13 aren't allowed on Instagram and that they kick them off, the jury said that he totally lost them with that. They're like, come on, dude. You guys don't kick them off. They're on there. Like all these kids under 13. Another one where there was a visible reaction and almost a gasp of sorts with the jury was there was a medical incident that happened with Kaylee where she had a bullying incident that happened at school, and the defense was cross-examining our case-specific causation expert, Dr. Baggett. And they were going through medical records, and the defense was saying, well, because of this bullying incident at school, Kaylee threatened to commit suicide, and she, had to go to the hospital, and her mom drove her there. And, so really it's the bullying at school that caused all of her issues, wasn't it? And we then got to get up and show the full context of the medical record, which was actually something happened at school. Kaylee ended up getting suspended. She got in trouble. And then her mom took her phone away. And that, in the medical record, Kaylee said, I'm going to kill myself because her mom took her phone away, not because of the incident of what happened at school. And when we showed that, and it was clear the defense was only showing a little cherry-picked part of the medical record, and we showed, no, hold on. She threatened to commit suicide and tried to let herself out of the car because mom took her phone away, and she called it her lifeline. That's what happened here. The jury was like, oh, there was like an
audible
feeling
gasp
in the air. Yeah.
So it backfired pretty hard, sounds like.
Yeah.
Oh, yeah.
They didn't bring it up again after that.
Never brought it up again.
Scratch that out.
Yeah.
So we're going to kind of transition to broader implications with product liability cases and parents protecting kids. So Mark is actually trying the second case, and now that's public knowledge, right?
Yes.
In these social media addiction cases. So what should plaintiff lawyers be watching for next? How is that going to go?
So in October 28th, happy Halloween to all of us on the trial team, we will be starting the next trial. There are two cases that are really similar. One is called KDB, one is called SJ. These are both female plaintiffs. One is 16, one is 18, but they both have hauntingly similar stories and experiences. They both have used all 4 social media apps, TikTok, YouTube, Instagram, and Snapchat. And they both of them have suffered from tremendous anxiety, depression, eating disorders, suicidal ideation, and suicide attempts. So it's going to be similar in some ways, but we're honing in. We always want to up our game. We don't ever want to try the same case twice. And we have a chance here to dig even more into certain documents and tell their story in the courtroom. So that will be happening in LA. We're actually trying to see if we can get the 2 cases consolidated together and try both of them. But that is going to be decided in about, a week or 2. We're going to argue that to the judge. And she's kind of in the position of she's previously not wanting to group them together yet, group some of these plaintiffs yet, and wants that to maybe happen a little later down the line. But these cases are so similar. They're the same case told and the same story told twice. So for these trials, we're hopeful we could actually do both of these together. If not, we're going to play a little jujitsu and we're going to work on both of them, and the
Yeah.
defense can guess and figure out which one we're going to end up trying. And we have a great trial team of amazing people that are ready to go for either one. So we get to surprise the defense.
Yeah. So hopefully, well, it sounds like juries are becoming more willing to see these digital platforms as, like products, not just product liability applying to physical things, but, these digital things. So, and hopefully as this goes on, these products are designed, more safely. But when it comes to parents, what would you want parents to understand about what came out of this trial?
I'll let Rachel speak to this a little more because she actually is a parent and I am not. But one thing that I would jump in and say is they need to be aware of how bad these apps are. YouTube has advertised itself before as let us be your digital babysitter.
Oh,
And parents need to know that what these companies are telling you is not true. They advertise themselves as trustworthy because they have certain protections in place without telling you that you have to go through 7 different clicks on the settings to just turn on one safety feature, and that the second you turn it on, your kid can also turn it off. So I would just caution parents to be, if you're going to let your child have a phone, educate yourself and your child on how dangerous these apps really are, and the fact that, everything you're being told is not the whole story.
Yeah, absolutely. Sarah kind of said something earlier a little bit ago that spoke to this point, in the sense that a parent's experience on these apps is entirely and completely different than a kid's experience on these apps. The algorithm is tailored to keep kids on as long as possible, because for these companies, time is money. It's advertising revenue. And that's how they make their money. Nothing is free. And if you're using a product that is free, you're not using a product, you are the product. You are the thing that the company is making money off of. So
right.
I think parents need to be incredibly careful and aware, and keep their kids off smartphones as long as possible. Go back to the old flip phone,
Yep.
um, or a landline. But it's hard, right? Because parents are battling their kids experiencing things like FOMO, and being the odd man out, or odd girl out, being the one that doesn't get invited to things because maybe they're not on the apps. And so it's a hard battle for parents. So I think transparency is really key, and knowing not to trust what the company's saying. Like Meta right now is going on and on about this whole shtick about Instagram teens, and oh, that makes it so safe for the teens.
Hmm.
And it's such bogus, because they don't do age verification at all. And the teen accounts, we've done testing and our experts have done testing, they don't work, they don't protect kids. And the way Meta was advertising this was, we use the same regulations for Instagram teens as the movies do for PG-13 and R-rated movies. And then Meta literally got a cease and desist letter from the entity that rates movies. And they were like, no, you don't do the same thing that we do. So
Yeah.
stop saying that you do. You are falsely advertising. So, I mean, it's impossible, but parents can't give up. They need to be hyper aware, hyper vigilant with all of this.
Yeah. Yeah, it's pretty scary. So, what do you think this case says about like corporate accountability in general when a company's own research shows these documented risks to vulnerable users?
Man, I am never shocked anymore at what a
Yeah.
multi-billion-dollar company can do. I mean,
Yeah.
it needs to start from the top: transparency, honesty. I think the jury trial system is the most important thing for accountability this country could ever have. We have to have communities of people tell companies to their face, what you are doing is unacceptable. The way you're treating America's children is not okay. You know, just to make a buck. And I think that I am a firm believer that the love of money is the root of all evil. It just is. And I think that companies have gone way overboard, and that, people who are the lowest ones at the totem pole at those companies can't even afford groceries. And then you have a Zuckerberg on his mega yacht, charting around like boxing in the middle of the ocean. Wow, there are people who can't even afford housing. And it's like, what are you doing, man? Like, you think this is cool? What are you doing? So
Yeah.
I think that I think the courtrooms have to stay wide open for accountability. I think companies need to know, if you are not being honest, if you're putting profits over safety, your day is coming and we'll see you in court.
Yeah.
Absolutely. I mean, I don't even have anything to add because that was very well put, but it is just surprising the amount of research these companies have that highlights the exact issues we're talking about, the exact safety issues, emails from people who work at the company who are parents saying, I see how children are struggling with this. We need to make a change. And it's the head in the sand. It's no, we don't. It's fine. Disregard. Don't read it. It's baffling.
It's kind of a unique case because with all this technology and like the amount of information they store, you have all these hot docs and all these bad things they're saying and emailing over years and years. So it's kind of making your case easier. Like you're saying it.
Yeah, we didn't even have to put it in our own words. They said
Yeah.
it for us. They just
Yeah.
didn't take any of it into account when making decisions. But I mean, the documents spoke for themselves. There were so many documents that the jury saw where you could see a visible reaction of anger and also confusion. So if you know these are problems, why are you not addressing them? Like Rachel said, it's just because of money. The more views they get, the more people are on the apps, the more money they get.
Yeah. They've invested in the science and understanding how it's affecting people. So it kind of worked for your favor. So just kind of wrapping up here. So what is one moment, if you can narrow it down to one, from the Meta YouTube trial that will stay with each of you?
It's a good question.
I think one moment that will stay with me is when we said in closing, Mark got really serious for a second, and he got really quiet, and he leaned forward and he took his glasses off and he looked at the jury and he said, you might think this is just a case about anxiety, or, how do you compensate mental anguish? How do you compensate a mental illness? It's not like she lost her life. She didn't lose a limb. But the question you have to ask yourselves is, what is the cost of a lost childhood? That, and you could see jurors tearing up. That was a big wow moment.
I'd say for me, it's the first time we showed Exhibit 5. Exhibit 5 became a really, really big piece of evidence that when Mark was arguing in closing, he kept saying, remember Exhibit 5, remember Exhibit 5. And the first time it was shown to the jury and we had someone walk through what it was just the acknowledgement that everybody needed, that these companies knew exactly what they were doing. Exhibit 5 was a feedback loop that showed essentially difficult upbringing, certain factors that make life harder, goes into all of these problems that you have, goes into social media addiction, goes into the problems, and it's a feedback loop and it intensifies everything. Social media is an integral part of kids who are struggling with XYZ things. Kaylee checked every single box and all of the harms that she has. Social media feeds directly into it, and it's a never-ending feedback loop that gets worse and worse and worse. And I think the first time the jury saw that, it was just a visual representation of everything Meta and Google did to this poor girl and to thousands of people across the country, and was such a good representation of why we were there and what needed to be fixed.
So there it is. And it's not the best image, but you can see poor self-esteem, negative body image, mental health challenges, and it all just feeds. Right?
Yeah. And it's a company document. The company made this. They
Wow.
were aware of this. Yeah.
So do you have any other advice for future plaintiffs' attorneys, Rachel and Sarah?
I think work-life balance is key. I think that it is so easy to lose ourselves in this job, but you can't do a good job for your client if you run out of steam and you run out of batteries. So people need to find a way, especially in trial. If you're a trial lawyer, it's so critical. You've got, such little sleep and it's so high stress. And so, any little bits of peace and calm, and whether it's a 5-minute walk outside and fresh air, just little things like that. I think work-life balance and finding a way to recharge your batteries is so critical, so that then you have the stamina to go out there and to right the wrong in the courtroom.
Yeah, that's good.
I'd want to give advice to young plaintiff attorneys, young incoming attorneys. I think something that I was told a lot in law school when I told people that I wanted to be a trial attorney was good luck, because nothing goes to trial anymore. And it's true that it's more difficult to get into the courtroom, but it's not true that you can't have a career in it. I wish I could go back in time and show those people what my email would look like, because I have a never-ending email chain with some of the people in the personal injury department at our firm where I say, anybody have something going to trial that they need help with? Anybody have a deposition that they need someone to take? And I email weekly all of these people and try to just get opportunities. So I would say that, but I would also want to give some kudos to a lot of the law schools out there. Rachel was saying earlier the importance of storytelling, the importance of, finding a way to make things interesting, demonstratives, themes, theories. And I know that a lot of lawyers don't do that. A lot of lawyers don't know that. But I know the law schools across the country are teaching it. I'm sure Baylor's teaching it. I know UT, the advocacy program, goes all in. We have entire courses on System 1 and System 2 thinking, storytelling.
Awesome.
How do you use demonstratives? How do you keep things entertaining? All the way down to using blue and black and red ink and certain types of markers and cardstock. Like, these things are being taught in schools now. So I would just say, watch out for the younger attorneys that are going to be coming out of law school, because I think a lot of them have really good foundations built from schools across the country with great advocacy programs. And I would just encourage them all to try their best to get in the courtroom, because it's really fun.
Last question, where can listeners follow your work and what the Lanier Law Firm is up to in general?
Great question. I think our website. Ironically, I think also there is a Facebook that announces things. I don't even have Facebook, but yeah, apparently the firm has a Facebook. So I do think the firm also has an Instagram, but I think
Not
our
for
LinkedIn.
long. They're going to come delete that real quick.
I know, right?
LinkedIn too, I think, is good.
Cool.
Oh yeah, LinkedIn's great.
Cool. Well, thank you so much for joining us and taking the time to help educate future trial attorneys.
Thanks for having us.
Thank you so much
This
for
was a
having
blast.
us. It was great.